All right, settle down, everyone. Good morning, KSLU law students, and welcome to today's explainer. Now, today, we are thoroughly dissecting question number 6, the rights of a finder of goods as a bailee under the Indian Contract Act 1872. So have your notebooks open and your pens ready. I am going to dictate the exact structure you need to draft a flawless 16-mark answer script. We are adopting a very strict exam-oriented approach today, all right? So pay close attention to the formatting and the exact statutory references I provide. Right. Here is our agenda for the answer. 1. Introduction and meaning. 2. Statutory rights and lien. 3. Expense and reward recovery. 4. Third-party interferences. 5. The right to sell. And finally, 6. Duties and conclusion. I want you to write this exact sequence as a synopsis at the very start of your answer. This immediately captures the KSLU evaluator's attention.
Okay, moving on. Heading number 1. Introduction and meaning. You will center this heading on your paper and underline it clearly.
Now, immediately beneath that heading, you must cite Section 71. Just write Sec. 71. Quoting the exact bare act provision right there in your introduction is absolutely crucial for high marks allocation. It tells the examiner that you're not just guessing, right? You actually know the precise statutory anchor for your answer. Section 71 is the absolute bedrock of this entire 16-mark question.
Next, let's read the definition exactly as it must appear on your script. Finder of goods, a person who finds goods belonging to another and takes them into his custody. The law treats the finder as a quasi-Bailee. Write this down. Now, take your pen and deliberately double underline the term quasi-Bailee. Why? Well, because there's no formal contract of bailment here. The finder and the true owner never sat down and signed an agreement. The law imposes this relationship upon them. Quasi literally means as if. The law treats them as if they are a bailee to ensure those goods are protected. Mark my words, the evaluator will be looking for this exact word.
Moving to the legal status, note these points strictly under legal status. Point 1, duties of a bailee. Point 2, rights similar to those of a bailee. You see, this is your structural bridge. It sets up the rest of your 16-mark answer by cleanly dividing the legal consequences of finding lost goods. The finder essentially steps right into the shoes of a bailee, inheriting both the burdens and the privileges. Okay, moving to the core body of your answer script, write down heading number 2, statutory rights and lien. Make sure it's bold and clear.
Right next to that heading, write down Section 168. Spotlight Section 168 aloud in your mind as you write it. I instruct you to place this statutory marker directly next to your point on lien. Section 168 provides the legislative backing for the finder's right to retain the goods against the whole world, including the true owner, until very specific conditions are met. Let's read the specific statutory rights off the slide. Right of lien. First, retain goods until lawful charges are paid. Second, retain goods until promised reward is given. Listen to me very carefully here, class. A lien is a strict right to retain possession. It is a possessory right only. It is not a right to appropriate, and generally speaking, it is not a right to sell. You are basically holding the goods hostage, legally speaking, until the true owner compensates you for the trouble you went through to keep their property safe. Write it exactly like this.
Let's move to heading number 3, expense and reward recovery. This is the next logical grouping of rates on your exam blueprint, focusing on monetary compensation. Notice this critical distinction on the screen. Reward promised. Can sue for recovery of reward versus no reward promised. Cannot sue, but may retain goods. I advise you to draw a 2-column table, exactly like this contrast block, directly on your paper. Why? If a specific reward was promised by the owner, say through a newspaper advertisement, the finder can institute an actual legal suit for that money. But if no specific reward was promised, the finder cannot sue for reward. They can only use their right of lien to retain the goods for their expenses. Visually demonstrating this clarity of the law to the evaluator is how you secure maximum marks. Following that, we have the third right to compensation for expenses. Read the bullets: reimbursement for preservation of goods and reimbursement for protection of goods. Now, why are these specific preservation expenses a statutory entitlement? Well, it's because the law doesn't expect the finder to be out of pocket just for being a good Samaritan. Think about it. If you find a stray cow and you have to feed it fodder for a week, you have preserved that cow. The true owner absolutely must reimburse you for that fodder. The 7th right on your comprehensive list is the right to retain reward. As the slide says, if finder acts on a reward offer, it becomes enforceable. This concludes the cluster of rights related to monetary compensation and rewards.
If the owner offered 5,000 rupees for a lost watch and you return it fully knowing of that offer, well, that is an enforceable contract. You have the full right to claim and retain that specific reward. Okay, prompt yourselves for heading number 4, third-party interferences. Get your pens ready because this is the most marks-heavy section of your answer, the case laws. Write this down strictly. 4. Right to sue third parties. Read the text with me. Can sue any person who interferes with goods. Can sue any person who causes damage or loss. You see, this is where average students write a mere generic paragraph. But this exact principle lays the foundation for a landmark judicial intervention. This is where excellent students secure university ranks. Even though the finder is not the true owner, against a stranger or a thief, the finder's rights are supreme. Let us dissect exactly how the courts establish this. Read this quote very carefully. Held that the finder has a better title than everyone except the true owner and can sue third parties. This is from the legendary case of Armory v. Delamirie. Now pause writing and listen to this deep case law breakdown. I want you to write the case name, Armory v. Delamirie, in a separate, clear boxed format on your script. What are the brief facts here? A poor chimney sweep boy found a piece of jewelry with a precious stone. He took it to a goldsmith's shop to have it valued. The goldsmith's apprentice deceitfully removed the jewel and refused to return it, so the boy sued. What was the ratio decidendi, the final verdict of the court? The court held that the finder of a jewel, though he does not acquire absolute ownership, has a right to keep it against all the world except the rightful owner. Now, what is the absolute relevance to the Contract Act? Why does it matter? Because it perfectly illustrates Section 71. The finder's possessory rights are fiercely protected against wrongful third parties, like that greedy apprentice. Write these facts and the ratio clearly. Moving along to the 6th right, right of protection. The slide clearly states, protected if acts honestly and protected if takes reasonable care. If you simply do these two things, the law shields you from liability. This perfectly transitions us to the next vital protection concerning wrongful claims. Let's look at the quote on the screen. Recognized protection of possessory rights against wrongful interference. This is the classic case of Hollins v. Fowler. Now remind yourselves to strictly underline this case name on your paper to secure maximum marks. Let's break it down. In Hollins v. Fowler, a cotton broker innocently purchased cotton from a fraudster and then sold it to a spinner. Fowler, the true owner, sued for conversion. The ratio decidendi established strict liability for wrongful interference with true possessory rights. But its relevance here is absolutely vital for you to explain. It reinforces that lawful possessory rights, like those of an honest finder taking reasonable care, must be legally protected. The law thoroughly recognizes the sanctity of lawful possession. Mentioning Hollins v. Fowler will demonstrate to the KSLU examiner that you have a deep jurisprudential understanding of bailment and tortious interference. Next heading. Heading number 5, the right to sell. This heading covers the most extreme power granted to the Quasi-Bailee. Spotlight section 169 right now. Write it in the margin. This is the ultimate statutory anchor for the right of sale that you absolutely must memorize. Section 169 dictates exactly when a mere finder magically transforms into someone who can legally transfer title to a completely new buyer. Let's read these precise conditions for the 5th right, the right to sell goods. You may sell when goods are perishable, or charges amount to 2/3 of value, or owner cannot be found with reasonable effort. Class, I instruct you to list these 3 conditions in exact, unmerged bullet points, just like this on your answer sheet. Do not combine them into a messy paragraph. If the goods are tomatoes, they are perishable. You must sell them. If the cost of feeding that lost cow we talked about has now reached 2/3 of the cow's actual market value, you may sell the cow. If you've advertised and searched diligently and the owner simply cannot be found, you may sell. These are strict statutory triggers. Finally, heading number 6, duties and conclusion. This guides us to the final structural components required to complete a solid 16-mark response. You must show the flip side of the coin. Note the duties of a finder verbatim off the slide. Take reasonable care of goods, not use goods for personal benefit, make reasonable efforts to find true owner. Contrasting the rights with these duties shows the evaluator a very comprehensive, balanced understanding of the topic. You have the right to a lien, yes, but you have a strict duty not to wear that lost Rolex watch to a party. You have a duty to actively search for the owner before you even think about exercising your right to sell under Section 169. Conclude your script strictly with these exact points on screen.
Conclusion: finder is not the owner, but given rights similar to a bailee. Ensures fairness and encourages honesty. Balances the interests of the finder and the true owner. Make sure you highlight these exact words in your final paragraph. Using terms like fairness and balancing interests leaves a highly strong, mature, and academic final impression on the examiner. It proves you truly understand the jurisprudential policy behind Section 71, 168, and 169. As we wrap up and you finalize your Indian Contract Act revisions, I want to leave you with this provocative, exam-level question to ponder. Look at the screen. Does the law of bailment actively reward honesty or merely tolerate it until the true owner arrives? Think about the very delicate balance of powers we just discussed today. Prepare well, structure your answers flawlessly using this blueprint, and you will excel. Class dismissed.